So why am I speaking? Well, the chances are that if you've got a business, by the time lockdown fully ends, either you will be in breach of a contract to somebody, or somebody will have breached a contract with you. So my talk is just going to look at the law of contract and some of the things that might apply if you're trying to figure out where you stand, if you're in breach or you're the victim of a breach. So firstly, it's a little bit of background to the law of contract in the UK, or in England and Wales. There's no law being passed freezing contracts during lockdown. You probably would have heard that people who don't pay their rent can't be thrown out for 3 months. The underlying obligation still exists. It's just the contract can't be enforced by law for 3 months. But that only applies to rental situations. There's no general law about the freezing of contracts. So contracts should have continued as per normal. Okay. I'm afraid you don't have a right not to perform whilst the other side's in breach. So if you've got a situation where the other side are in breach to you and you're the victim, under the law, you're meant to still continue your performance. So the way you're meant to respond to a breach is either carry it on, continue to carry on the contract, but ask for damages, or ignore the breach because it's small enough to forget about, or to say, I'm going to end this contract and then seek damages. You can't do tit for tat, okay? It doesn't work that way. Similarly, it might surprise a lot of you to know that under the general contract law, there's no right of set-off. So if, for example, Lawrence and I have a contract, 2 contracts rather, and they're for separate things, okay? I owe Lawrence money on one, he owes me money on the other. I can't turn around and say, I know under my contract I owe you 10, but I owe you 5 under, you owe me 5 under the other one, so I'll just pay you 5. As far as the law is concerned, each contract is a standalone silo. So you can't just do that sort of set off, tempting though it is. The only time you can do that set off is if it ends up in court, you can use it as an argument or a defense. Okay, but outside of court in the general world, you can't just say to the other side, I'm not paying you 10, I've decided to pay you 5, Lawrence, because you owe me 5 on that one. You can't do it, I'm afraid. Okay. Oh, Tracy, you've raised a hand. Do you want to type a message to Simon, and then he'll tell me what the question is. Simon? Okay. Oh, there's a mistake. Okay. Okay. All right. So carrying on. So if you're in a situation where you've broken a contract, or you're the victim, I can't really use the word victim in contracts, but we'll use that as a shorthand. If you're a victim of somebody breaching a contract, the first question you've got to ask in either case is, what does your contract consist of? Quite often contracts are just a document that you've both agreed, but very often nowadays they're a whole mixture of different things. They're something in an exchange of emails, plus stuff on a terms and conditions on a website, possibly a signed contract, possibly some other conditions just stuck at the bottom of the actual purchase order or job order. So before you get into any battle about breach of contract, make sure you're clear what your contract is and what terms you need to look at. Okay. Second question to ask yourself is, who is in breach, who's responsible for that breach, and who's the victim? What I come across an awful lot is that although contract law expects you to be very, very precise and accurate and considered, of course, real life isn't like that at all. And you end up doing deals with, you sign up with company A because Bob runs company A and you like Bob, but then actually company B, which is also owned by Bob, delivers the stuff that you've just bought, and then it all gets messed up. Okay, so be really clear who the parties are. Okay, is the people who signed the contract the people who've done the thing? Is the victim somebody who signed the contract? Because under English law, there's a thing called privity of contract, which basically means that if you haven't signed a contract, if you're not party to a contract, it's very hard, not impossible, but hard to enforce it or to demand or to be held liable under it. So work out who's involved before you do anything else. The third question I'd look at is the main one, obviously. Is there actually a breach? I do get quite a few people coming to me and saying, X promised to do this and he hasn't done it and he's in breach. Okay. And then you look at the contract, and actually what you're outraged about is the behavior of X, but there's not necessarily a contractual breach. So how do you work out whether there is actually a breach in your contract? Well, the first thing you'll do is you look within the contract itself, having worked out what constitutes a contract earlier. And there's a few questions to ask yourself. Is it a major or a minor breach? That's really important. Okay. If I've got a contract with Lawrence to deliver him 1,000 head of cattle, okay, for £10,000, then okay, and I don't deliver the cattle, he doesn't deliver the cattle, or I don't pay the money, that's a major breach. Okay. If, however, I deliver 9,999 cattle, or Lawrence pays me £9,999 instead of 10,000, that is not a major breach. Okay. So and what's the difference? The difference is that with a major breach, the person who's the victim is allowed to end the contract and sue for damages, or what's called specific performance, asking the court to make the other side do what they had promised. With a minor breach, you're not allowed to end the contract. You can sue for any loss, okay, but you've got to carry on performing the contract. So make sure you've classified your breach first. Next, do you have a force majeure clause? You've probably all heard this term a lot recently. Basically, it's also known as an act of God clause. Under English law, under English contract law, there is no implied force majeure clause. Okay, a force majeure clause is like a freezing clause or a suspension clause. If something that is unexpected, was beyond the expectations or belief of the parties happens, like COVID-19, in a way that makes it impossible for you to perform your contractual obligation, then if you have a clause that covers that situation, and a lot of insurers are arguing that they don't, then effectively your contract obligations are temporarily frozen. Okay, you're not in breach for not performing. Your obligation requirements are frozen. How long are they frozen? What happens after that? That is determined by what the force majeure clause says. It's all down to the wording. Some will say you've got 30 days or 6 weeks, you've got to give notice. It varies tremendously. So if you've got a clause, you can rely on it, possibly, depending on the wording. If you don't have a clause, you can't imply it. Secondly, is the breach handled in the contract? Quite often, the contract will have foreseen the possibility of a particular obligation not being fulfilled, okay? And it may have provisions about what the parties must do if that happens. The irony there is that because you've dealt with it in the contract, if I've got to deliver to Lawrence 10,000 head of cattle, if I don't, then I've got to do X, Y, Z. It's not actually a breach, because the contract, we're performing the contract, we've just gone down a different route in the contract. So look to see if the contract's handled. That's very important. Lawyers love words, and lawyers love precise words. So you've got to read things really carefully. Don't skim read a contract. That's like putting a gun to your head, okay? Look at the words in real detail. So is there a discretion allowed? To lawyers, there's a big difference between shall or may, okay? Or must or reasonable endeavor. So Lawrence shall deliver the cattle, okay? No choice about it, he's got to do it. Lawrence may deliver the cattle. That gives Lawrence flexibility and options. Big difference. Similarly, Lawrence must deliver the cattle, no choice. Lawrence must use his reasonable endeavors to deliver the cattle, means that he's got to try, but if he fails, it's not a breach. So look very closely at the wording.
James, can I just ask a question on that?
Yeah, sure.
If you receive a contract to go over, which is full of mays and maybes,
Yeah.
What do you do?
What would I do?
Yeah.
Yeah. Well, also, what was anyone do? Well, you basically look at the important pinch points. A lot of maybes or where we'll say may instead of shall is because either it's not so important, or because they've got a couple of options: may do this or may do that. Okay. So just read it as a plain English document and just say, okay, may, that means they've got discretion. Will it hurt me if they exercise discretion against me? If so, ask for it to be changed to shall.
Okay.
Okay. Does that answer your question?
Thank you.
Okay. Yeah. Okay. So next, having looked at the contract, the next thing I would look at is what's outside of the contract that may be relevant. Okay. And there are certain legal principles that may apply even, and they're not referenced in the contract itself. The first one is frustration. Okay. Frustration is sort of like force majeure, but it's not the same. It's a very complicated old area. Frustration is where something happens after the contract's been entered into that makes it impossible to perform, or changes the nature of what you have to do so hugely that it's effectively a completely new contract. In those cases, the contract may be allowed to die. Okay, but it's very much and very complicated, and it depends on the exact wording. Let me give you an example. Okay, if I had a contract, if I was an advertiser and I had a contract with ITV to buy an advertising slot during an important sports event that they were going to broadcast. Okay, if the contract said, I will buy a 30-minute advertising slot during the halftime for these. I don't think Premier League's on ITV anymore, but let's say it's Premier League. I have a contract to buy a 30-minute advertising slot during the halftime period of 7 Premier League games between, January and May. Okay, that contract, or sorry, March and May. That contract is frustrated because there are no Premier League games on. Okay, so you could claim frustration. However, if your contract was worded to say, I'll buy a 30-minute slot at 7:27 on this date, 7:27 on this date. In other words, I'd worked out when the games were and I just specified the date and the time, exact time. Frustration would not apply because I could still have an advert then and they would still run it. It would be for some crap old, Poirot or something. Okay. So although commercially the contracts are now rubbish to me, I can perform it, or it can be performed. Therefore, frustration wouldn't happen. Illegality, that's when the government makes something illegal. Okay, so typically you can't have an enforceable contract to murder someone or to deal, a drugs deal. Okay, so obviously with the government doing lockdown, forcing those businesses that were forced to shut, okay, may be able to claim that it would have been illegal for them to perform the contract. Okay, so but you've got to look at the exact wording of the statute and how it applied to you, and you'd be expected to try and work around it. So if, for example, the contract said you will deliver 5,000 burger buns to McDonald's, these various stores, okay, next week, but then the government locked it down and forced McDonald's to close, okay, it would be illegal for you potentially to try and deliver those burgers, okay. So I mean, it's a grey area, but that would be an example of where illegality might be to your advantage. Sorry, I'm just very conscious of time. Counterclaims. Do think about how COVID will have affected the other side as well. Again, using that example of McDonald's, if I've got a contract to deliver the burger buns to their various stores on a particular day, okay, either impliedly or expressly in the contract is an obligation of McDonald's to be open to receive the burger buns. Okay, so if I've got a situation where, and this becomes anticipatory breach, the next point down, if I know that I pay a delivery lorry to deliver those buns and that they're going to be turned away or they're not even going to get in because there's no one there, and I've got to then waste that money of the delivery driver, waste the money of it having returned, waste the money of the burgers, the buns that have gone off, although I'm not sure McDonald's burgers buns ever go off, then that would be, I'd have a counterclaim. So if McDonald's sued me, you didn't deliver, I would counterclaim, you refused to let me deliver. And I knew that anticipatory breach. I was anticipating your breach, and I'm going to make a counterclaim for that. So think about the other side as well. Okay, moving on very quickly. If there is a breach, are there any technicalities that might help or hinder you, depending on whether you're the victim or the perpetrator of the breach? Well, first of all, look to see whether notice has to be given of any breach. It's quite common in contracts for contracts to say, if one side feels the other side's breached the contract, they must notify them within X number of days or weeks of the breach, giving full details. Okay, that obligation is as important as the obligation to pay for the burger buns. Okay, so if you don't do that, you may not be able to sue because you haven't fulfilled the contract terms. Okay, so watch out if there's any notice provisions. Similarly, are there any dispute resolution procedures in the contract? So, for example, it might say you've got to go to mediation first. If you've got to go to mediation first or arbitration, you can't go straight to court or even just threaten it. Okay, mitigation is required quite often. It's a standard policy of English law that if you've suffered loss, you can't sit back, light up a cigar and say the money's going to roll in. Okay, you've got to take steps to lessen the loss you're suffering. So I've got to deliver, say to Lawrence, I've got to deliver 5,000 cabbages. Okay, Lawrence doesn't want to take the cabbages because all his shops are closed. Who else can I sell those cabbages to? Okay, maybe I can sell them to a waste composting company. I mean, it could be to anyone, or just somebody who loves cabbages. Okay, stay away from that person. Okay, so, but maybe I'll only get £1,000 for them, or even £100. I still have to do it because if I go to court to sue Lawrence, I want my £5,000 because he didn't take the cabbages. The court will say, could you have sold them to somebody else? Yeah, they've got 1,000 for them. They'll say, okay, then we're going to give you £4,000 in damages, not 5,000, because you sat on your backside and refused to save that £1,000, and that's not fair on Lawrence. Okay, insurance. Does anyone involved in this sad mess have insurance? By sad mess, I don't mean this conference, of course. Because under English law, if there's been a breach of contract and you're claiming damages, the idea behind damages is it puts you back in a position you would have been in if the contract had been performed. So if you thought you were going to get profit of 100, then you sue for 100. Okay, but if somebody's got insurance or you've got insurance and your loss is actually 0, don't take it for granted that the court's going to say, oh, well, you've already got 100, so you've lost nothing, but here, have another 100. Okay, because you've not at that point suffered any loss. You might be able to sue for the cost of the insurance that you had to get, but don't take it for granted if there's insurance involved. Has the breach been waived? This doesn't tie to the first one, notice of breach, but it's sort of similar. Okay, if somebody breaches a contract, you've got a contract, somebody breaches it, and then you just carry on doing the contract as if it hadn't happened, okay, which happens in big contracts all the time. I've got to deliver, 1,000 of these to you every week. 1 week I deliver 500, but next week I deliver 1,000, so you carry on. Or your tenant doesn't pay your rent or doesn't pay all the rent, then you are at risk of the court saying, oh, tough, you left it too late. By in effect not saying anything about the breach, by not saying you reserve your rights, or I'm going to talk to you about that later, you may well have waived your right to go after them later. So be careful on that. Setting off we discussed earlier. Okay, and the last one there, should part payment be made? is probably a sneaky one, and morally I'm embarrassed to say it, to have put it in, but it's important, even though it's a defense mechanism. People argue about money, people argue about settlement. So I've got an argument with Lawrence. Lawrence says I owe him 10. Okay, so I don't agree. So I say to Lawrence, I owe you 5. And I pay 5 into Lawrence's bank account. And then Lawrence, because cash flow, well, with Lawrence, cash flow isn't tight because Chris did such a good job, but let's pretend it was, then if Lawrence takes that 5 and spends it, okay, I can turn around and say he's accepted 5 as in full and final settlement. And that may stop Lawrence going after the other 5. There's a very good chance of that. So be careful when people do make part payments, that if you're only accepting it as a part payment, you make that very, very clear. And to be on the safe side, probably don't accept it at all. Oh, I've missed out question number 6 because I was very bad at maths. I became a lawyer because I'm no good at maths. I would have been an accountant otherwise. So this is question 7, but it's actually question 6. Really, the last question you should be asked, in some ways, perhaps the first question, is this really worth fighting over? The truth is that litigation is like poker, okay? I don't mean to in any way to diminish the seriousness or the consequences or the anguish caused by somebody breaching a contract. It can be life-changing. But in reality, the law is just another tool that people use, okay? It's about the people more than the law often. So before I'd look at my legal position, I'd look at who I was up against. Who are they? Are they weak? Are they strong? Are they aggressive? Are they forgiving? Are they lazy or are they on the ball? Because you can have the best claim in the world, but be half-hearted about fighting it, you're going to lose. You can have the worst defense in the world, but be ferocious in fighting it, and you may win. So it all comes down to people. Next, where are they? If you've breached the contract of somebody in Eastbourne, you're probably in trouble. If you've breached the contract of somebody who's in Yemen or China, then the chance of them suing you are probably so low, you might want to just take a risk. Whose laws and courts apply in the contract? If it's the law of Yemen, okay, and the courts of Yemen, do you care? Let's say they go to the courts of Yemen and get a court order against you. Almost impossible to enforce. Who cares? Okay. And then the last thing there, is it clean or messy? Is the case clean or messy? Okay. If it's really clear cut and really clean, then people settle quicker because it's clear that they owe the money. If it's messy, they'll say black and white, black is white and up is down, just to muddy it up. Okay. So that will make a big difference to whether it's worth fighting and how much it's going to cost. And the question, do you have evidence? Outrage is not evidence. Okay, do you have evidence? Okay, that's all I've got time for. So thank you very much. Do please feel free to ask any questions or come back to us if you want a consultation on your matter. As Sam said, I've given a real overview of something very general. So if you've got a specific legal question, problem, get specific legal advice, please. Thank you.